Yes, Mr. Robinson.
My Lord, perhaps I may start by summarizing the position with respect to the buyer's rights pursuant to Clause 6 of the contracts. The buyer, my lords, has no contractual right under Clause 6 to recover either the principal or the interest payments made. The basis for recovery has to be one in quasi-contract, applying the principles of unjust enrichment. Now, this principle was recognized and applied by Justice of Appeal Ricks in the Court of Appeal. And we submit, my lords, that this is a correct statement of the principle. It appears at paragraph 56 of the judgment, which is at page 16 of the electronic bundle. There he says, as for Clause 6, I see nothing there to exclude the effect of the principles of restitution. And I will come back to say something about that sentence, my lords. There are express provisions for the forfeiture of the deposit and all and any interest accrued thereon, and also for the retention out of further sums paid by the buyer of sufficient to compensate the sellers for work done on the property at the buyer's request. But there is no express provision for the return to the buyer or part payments other than the deposit. That is left to the general principles of law assumed rather than expressly spoken. And there his lordship inserts a footnote, which I suggest it is useful to read. As so often occurs, see the comment of Burroughs, the Law of Restitution, 3rd edition, quote, it will be very unusual for them to deal with restitution to each other. Quite simply, the parties' intentions run out on this issue, and one needs to turn to the imposed obligations of unjust enrichment. His lordship goes on, and that is despite the further language of the clause that neither party shall have any further rights, demands, actions, claims, or damages, the one against the other. It was common ground, at any rate on the appeal, that this provision did not stand in the way of the buyer's right to recover what the law permitted by way of restitution. The question then arises, what does the law allow by way of restitution? In my judgment, the law does not allow more than a figure which takes account of the value to the buyer of his possession, and which of course will vary with the time of the default. And if I may just revert to the first sentence in that paragraph, I see nothing to exclude the effect of the principles of restitution. This, my lord, appears to be a reference to the principle which is stated in Goff and Jones at paragraph 327, which is at page 1167 of the bundle. Where it provides that a contract, where it states that a contract may expressly exclude or limit a claim for unjust enrichment. Any such exclusion must satisfy 3 requirements before it will be given effect. First, it must be incorporated into the contract. Second, it must, on proper construction, apply to the claim being brought. Third, it must not fall foul of the statutory controls on such terms. So that was the starting point of Mr. Justice Ricks when he's addressing this issue. He's starting by saying that there is nothing to prevent the recovery of certain amounts paid under the contracts by virtue of applying the principles of unjust enrichment, specifically on the basis of a total failure of basis. But his approach to the interpretation of the contract is such that he is taking the approach that to the extent that there are no express provisions for forfeiture with respect to anything other than the deposit and those sums which are specified there, then it means that the avenue for recovery would have to be through the route of the claim applying principles of unjust enrichment. Now, I did submit earlier, my lords, that when taking the proper approach to a claim based on unjust enrichment, one may look at the terms of the bargain without being constrained by the terms of the contract or by the scope of the contract, unless the contract itself contains specific terms which prevents the court from doing that. And there is a very helpful statement in the speech of Viscount Simon in Fibrosa, Spolka, Axinia, and Fairburn. That is at page 1401 of the bundle, specifically at page 1415. And referring to a very lengthy passage which he quotes, Viscount Simon goes on. It appears to me that the reasoning in this crucial passage is open to two criticisms. A, the claim of a party who has paid money under a contract to get the money back on the ground that the consideration for which he paid it has totally failed, is not based on any provision contained in the contract, but arises because, in the circumstances that have happened, the law gives a remedy in quasi-contract to the party who has not got that for which he bargained. It is a claim to recover money to which the defendant has no further right, because in the circumstances that have happened, the money must be regarded as received to the plaintiff's use. So that is what, my lords, lead us to the recovery of the principal payments. There has been no argument in this case at any stage of these proceedings, from first instance through the Court of Appeal to this committee, that the buyer is not entitled to recover the principal payments. That has always been conceded, and that is supported in very clear terms by all the authorities. The dispute has been whether the interest is part of the consideration for the transfer of title as contended by the buyer, or, as we contend, whether or not that is in fact severable and is referable not to the contract for the sale, that is to say, in return for the transfer of title, but referable to the circumstances which we have seen as they have developed, whereby possession was granted and there was what has been described in both the Grand Court and the Court of Appeal, an owner-financed transaction, by virtue of which the buyer could enter into possession, use the premises for commercial purposes, for his own benefit, and to the detriment in that sense, that narrow sense, of the seller, who, had the seller not entered into this arrangement, the seller could either have used the premises for his own commercial purposes, or could have sold the premises for money which is paid in full as at the time of purchase, or if even under a similar owner-financed arrangement, whereby the seller is compensated over time for the money which would otherwise have been paid at the time of the contract, or at the time of, at least, of completion of construction of the buildings. So that, my lords, would take me to the issue of severable or divisible consideration. It is my respectful submission, my lords, that the principles outlined in the passage from Mart, referred to by my learned friend, and which is included in the authorities before your lordships, should be applied in this particular case. There is no good reason in principle or in authority why they are not applicable. I did note some element of hesitation, both by Mr. Justice Williams and by Sir Bernard Ricks, in applying those principles, especially with respect to the trial judge. It appears as if he had some regard to the fact that there is no English or Cayman authority to similar effect. Now, there might be explanations for that in terms of the circumstances in which the courts have had the opportunity to deal with situations as exist in this particular case. And during the course of argument, your lordships had asked my learned friend to address the question as to whether or not, or the effect of the fact that Australia and the Cayman Islands have similar systems of registration of titles. And I would accept that the fact of the existence of similar systems of registration of title by itself does not mean that it does not provide assistance to how these contracts are to be interpreted and how the principles regarding unjust enrichment are to be applied. Those are principles of common law developed in the various common law jurisdictions based on the circumstances which have been presented to the respective courts. But perhaps an explanation for why it is that these installment payments, installment contracts, seem to have had more prevalence in Australia than they have had in England. An explanation appears to be provided in the extract from the paper presented by John Toohey, which was referred to by the trial judge, and which is in the bundle. It starts at page 1210, but I would like to direct your lordship's attention to page 1211. We should also take into consideration that this was written in 1964, but the practice in Australia certainly had developed to some extent by then, as we have also seen from the cases which were referred to in the extract from Mart, because these are all cases of much early vintage. The paragraph which starts, because of the rarity of the terms contract in England, and because of its prevalence in Australia, the law of this country relating to default in the sale of land has tended to develop along rather different lines from that which it has taken in England. This difference has not been just academic. One illustration being the question whether a vendor who has rescinded because of the purchaser's default can sue for damages as well. This right, which was affirmed by the High Court of Australia in 1933, is apparently still rejected in England. That area of the law has now moved on in England, and in England it is now accepted that it is not necessary for it is not necessary for the contract to be void ab initio, etc., in order for to pursue a claim for restitution. The article continues, why is it that the practice of land sales has differed in the two countries? Dr. Stolchar has suggested that in England, the purchaser would wish to acquire full title, if only to reconvey to a mortgagee, and he would want this in order to discover immediately any possible defects in title. Whereas, under the torrent system in Australia, the purchaser would know at once what sort of title he would ultimately acquire. There is no doubt, this is no doubt is correct, and a further explanation may well be the availability of finance from lending institutions and private lenders in the two countries, etc. It is one possible explanation which is canvassed here, but what is recognized both in the academic writings and in the authorities is that there certainly has developed a practice in Australia, in the various states in Australia, a practice of some lengthy duration whereby these installment contracts have been entered into, and the courts appear to have taken a position whereby when dealing with restitution, claims for restitution, whether they are by virtue of claims made in law under the first category identified by Lord Justice Denning in Stockloser and Johnson, or by way of claims for relief against forfeiture, the approach has been taken whereby the interest payable on these installments is treated differently from the interest payable on the, treated differently from the principal payments made towards the purchase price. And perhaps if I may go quickly to the two of the Australian cases which were referred to which in the Mart extract, and which my learned friend took your lordships to. First, Berry and Mahoney, and Mallet and Jones. Now, Berry and Maloney is at page 1309. And this was a case before the full court of the Supreme Court of Victoria. And it was a claim for the grant of relief from forfeiture of installments paid under a contract for sale of land. And that contract was rescinded by the vendor on the default of the purchaser. The court, as it happened, granted relief from forfeiture. But in doing so, did not allow the purchaser to recover the interest payments which were made. This was a purchaser who, like the purchaser in this case, had been let into possession. Now, there are a number of questions which were submitted by special case to the court. These are set out at page 1312. They're listed there, numbered 1 to 10. And number 5, that question says, has the plaintiff and or have the purchasers any right to be relieved against the forfeiture of such monies or any part thereof? Number 6, upon what terms, if any, should such relief be granted to the plaintiff? Now the court answers those questions at page 1318. And in relation to questions 4 and 5, the answer is to be found in the answer to question 6. And in relation to question 6, the answer is there stated, such relief should be granted upon the following terms.
Sorry, you're at page?
Page 1318, my lord.
18, thank you.
Yes, 1318.
Yes, thank you very much.
Yes, there should be an inquiry as to the amount of purchase money paid to the defendant in respect of the hotel, the license, and the goodwill of the property, but not including the amount paid for furniture, the furniture remaining in the possession of the plaintiff. There should also be a second inquiry as to damages sustained by the vendor by the loss of his contract. subject to the deduction of the amount ascertained by inquiry number 2, and subject to also the adjustment on ordinary principles of the rights of the parties in respect of occupation and interest, the plaintiff should be relieved from forfeiture, and the defendant should be ordered to repay to the plaintiff the balance so ascertained. So, and this appears to have been done without too much argument, not much discussion there, but it is treated. And this is a case which has existed for a very long time. It's a 1933 case, and it is still being referred to by Mart, which is a text, this edition being published in 1995. So the other case, my lords, is Berry and Mahoney. I'm sorry, that was Berry and Mahoney. The other one is Mallet and Jones, which is at 1511. Now, my learned friend did take your lordships to these cases. But in his submissions, he made light of the fact that there appeared on his submission to have been some agreement with respect to the entitlement to interest. Now, your lordships will recall just one moment, sorry. That in this case, which is at 1519, the terms of the contract are there summarized in the judgment because they are based on the application of certain standard contractual terms. And they are summarized there as to the rights of the parties in the case of rescission based on breach by the purchasers. My friend took your lordships to that section. And then in the section below, which was read by my learned friends, there is a reference to the fact that with respect to the amounts recoverable by the plaintiffs, the amounts which was paid towards interest on the installments were not to be considered as installments of purchase money within the meaning of Clause 7. Now, that is a position that we have taken in this case. We took it at first instance, and we submit that that also should apply in terms of the interpretation of Clause 6, that the payment, the interest payments, certainly in the context of this case, based on the interpretation of the bargain as arrived at by the Court of Appeal, were referable not to the capital sum paid towards which was to have been paid in return for the transfer of title. So these cases, my lords, do provide some assistance, as do the English cases, which we can see from the analysis done by Sir Bernard Ricks, although they do not have facts which are identical to the facts of this case. There are certain elements. So, for example, in Stockloser and Johnson, that was a case in which the purchaser was in possession, and there was a significant delay in the claim for relief against forfeiture. And the court in that case refused relief against forfeiture. And Mr. Justice Ricks in the Court of Appeal in this case recognized that the fact of possession may have had some relevance to the fact that the court refused relief against forfeiture. So those cases are helpful in terms of the development of the principles. The Australian cases are helpful in terms of their specific application. We have in the written case, my lord, referred to the cases which deal with the principles of severability, of consideration, and we would ask that your lordships apply those principles to this case in light of the circumstances which we say suggest that the purpose, the basis on which the interest payments were made was quite different from the basis on which the principal payments were made on any proper and rational analysis of the agreements in this case. We have in the written submissions, my lords, addressed the hire purchase cases which have been referred to in the appellant's written case, and also which were referred to by my learned friend during his submissions. I would only refer your lordships to the written case with respect to what we see regarding those cases and why we do not why we submit that they are not applicable to the facts and circumstances of this case. Accordingly, my lords, the result arrived at by the Court of Appeal was the correct result, even though they may have taken a route which may not be seen as exactly in line with the authorities. That is to say, to use what my learned friend refers to as the counter-restitution methodology. The Court of Appeal could have come to the same conclusion without approaching it in that manner. But one has to have some sympathy for the Court of Appeal, and to that extent, the Grand Court, because the case was never put in that way. It was always pleaded as a case in contract, based on interpretation of the terms of the contract, and all the wealth of authority which has developed. Some in very recent times, neither court had the benefit of those authorities. There were some cases which were mentioned and dealt with both at the Grand Court level and in the Court of Appeal. But certainly, neither court had the benefit of the more exhaustive review of the authorities which your lordships have had on the hearing of this appeal. Nevertheless, my lords, we submit that there is no basis to disturb the decision of the Court of Appeal. The decision should stand. The appeal should be dismissed. Those respectfully are my submissions, unless your lordships would like to hear from me on any specific point.
Thank you very much indeed, Mr. Robinson. Mr. Watson? my lords. Having been rather pleased at undershooting my estimate by 7 minutes, I've been comprehensively upstaged in terms of time estimate. I only have, I think, 4 very short points in reply. I was asked by Lord Briggs when the agreement to permit possession was entered into. And
you were saying, well, there's nothing to show it wasn't contemporaneous.
Yes, I was actually wrong about that. It's part of the defendant's pleaded case that it was afterwards. If one goes to page 187 of the defence and counterclaim, paragraph 6.4, the pleaded case is that the defendants permitted the plaintiff to enter into possession pursuant to an oral agreement entered into by the plaintiff and the second defendant between the date of agreement for sale and the date of possession. So this oral agreement was entered pursuant to clause 5 or
Where are you?
page 187.
It's 6.4. Oh, it's just on the bottom of my page, yes. Thank you. Yeah.
So the agreement, we can't precisely date it, but it was between the date of the agreement for sale and the date of possession in respect of in respect of shot 10, and then at page 189, clause 9.4 is pleaded in the same terms. The defendant permitted the plaintiff to enter into possession pursuant to an oral agreement entered into between the date of the agreement for sale and the date of possession. So
189, paragraph.
Paragraph 9.4.
Thank you very much.
So the agreement wasn't in fact contemporaneous, but on the defendant's case, and no issue taken with this, it was at some stage after the agreement for sale, but before, plainly it would be before possession was in fact granted. And the second point arising, but Lord Kitchen asked me what the consideration was for the agreement, and Lord Briggs asked me a number of times what the in discussions what the terms of agreement were, whether there was anything beyond payment of the strata fees, and it does appear on the evidence that my client also paid the insurance on the properties, and one can see that at page 229 of the bundle, paragraph 24 of Mr. Richards' witness statement. Where at the 5th line down, he said, I paid the insurance for 15 years on the units, and I don't believe I should have been responsible for that element of the strata fees. And
is there any pleading about how the precise instalment plan was agreed or imposed? We've seen the worksheets and we've seen their commencement date, so I understand it's probably consistent with every possession completion of works. It's a document, as I understand it, provided by the seller to the buyer, with which, until default occurred, the buyer complied.
yes, well, my client, I think it's common ground that my client paid the sums from the date of completion or entry into occupation. There wasn't a to my knowledge, there isn't a pleaded allegation, essentially, that there was some form of variation to the contractual terms that the date for payment of, because it was payment of both principal and interest that began then, that it should begin then. But I think it was common ground that the interest and amortisation worksheets were periodically produced, and that...
You say it was pleaded as a variation?
No, it wasn't.
It wasn't pleaded?
There's no plea as to
No plea at
variation.
all. That's what I thought the position
Yes.
was.
Yeah,
Yes.
but there wouldn't be a variation because, as I was pointing out before lunch, clause 3B was never completed. We knew there was 20 years of payments, and clause 3B would have had, if it had been completed, a date of the last instalment.
Yes.
But because presumably at the time the contract was entered into, one didn't know when the construction would definitely be completed and when possession would be taken, that was left incomplete. And therefore there didn't need to be a variation. But it was merely a further step in the completion of the agreement.
Yes, well, I think I would have to accept that. I'd have to accept that there was at some stage, a date agreed between the parties on which my client started making payments. Whether one analyses that as the date of completion of the works or the date of possession is not one on which there was factual exploration or a finding.
Yes.
But certainly in relation to the payment of insurance, that was something that initially wasn't contemplated in the contract. And you can see that from page 527 of the bundle in the schedule. At clause 3 of the schedule, it says, notwithstanding any rule of law or equity to the contrary, the risk of the strata lot shall not pass to the purchaser until closing, and until such risk passes, the vendor shall keep the strata lot in the buildings within which it is constructed sufficiently insured against all risks. But my client's evidence was that he paid the insurance. One infers that was part of the agreement. The third point relates to the construction of clause 5. I don't propose to go over the submissions I've already made, but I do note that in construing clause 5 of the agreement, one really does have to begin with the words of that agreement, and that is, in my submission, lacking in the case, both of the respondents and the outcome determined by the Court of Appeal. Now, there was no pleaded case, plainly, as to rectification of that agreement or any implied term. None was alleged. And there has never been a suggestion, other than at the most general level, that possession was envisaged by the contract, as to why those words are there. And I would say that the reason that the words are there is because they mean what they say, that possession will be given at closing, and plainly the parties had some trust in each other that they would come to an agreement about possession earlier than that. But I also note that in making the submission that possession was in some way agreed, and therefore that interest ought to be apportioned as consideration for that possession, there was very little attempt to link the interest payments with the fact of possession. The reality is, as Justice Appeal Ricks identified at paragraph 45 of the judgment, this is at page 13, interest is a factor of price and interest rates at the time of the contract rather than a way of pricing possession, as the judge below remarked. That goes to the Australian solution as a matter of principle. In any event, most of the interest will be payable in the earlier period and less of it in the later period. So it is unlike rent, which is priced more evenly, and if anything is as likely as not to rise over time. That goes to the solution in technical or functional terms.
But that ignores, doesn't it, the use which the seller has of the instalments as they come in. The interest may start high and end low, but his enjoyment of the capital payment starts low and ends high, and they, broadly speaking, balance each other out.
Well, it would depend on whether or not the interest under the contract is the same as the prevailing interest rates. But I understand as a broad proposition.
Of course, he may make more or less advantage of the capital in his hands, I appreciate.
Yes.
But there's an overall symmetry, providing one doesn't ignore that part of the way in which the use of the price side of the equation worked.
There is a symmetry, but it's linked to the purchase price and the use of the purchase price rather than to the occupation.
Oh, yeah.
It's not related to a question of rent, is the point that I'm...
It could be related to either, couldn't it, or indeed both?
Well, the relationship, the question of what the rental value and what the value of possession is probably won't have much of a link to the interest, because the interest is a percentage of the capital. Now, it may be said, well, might there not be some link between the purchase price and the value of occupation, in the sense that properties that are very valuable tend to have higher rental payments and properties that are not very valuable don't. It's not clear whether that was the case in this case, other than in very, very general terms. And obviously the rental value of the properties fluctuated quite substantially over time in a way that the interest didn't. The interest...
But it might be said against you that the quid pro quo is cruder than that. The seller gets the use of the price during the 20-year period, either because he's got a part of it or because he's being paid interest on the part he hasn't got. The buyer gets the use of the property during the 20-year period by his possession of it.
Well,
and one is the quid pro quo from the other. One doesn't have to go into fine calculations as to who gets the better bargain.
I quite understand that. I think the difficulty with that analysis is that it doesn't reflect any terms of the parties' contracts, and that quid pro quo is quite right that something could be agreed, in that you could agree that for as long as you're in possession, you'll pay interest, and if you're ever out of possession, you won't pay interest. But that wasn't the contractual terms that were agreed in this case.
No, but it was, if this contract had run its course, and the Unit 10 contract almost did, could it not be said that throughout that almost 20 years, let's assume it ran the full 20 years, the seller did in fact get the use, or something equivalent to the use of the price, and the buyer did in fact get the use of the property once the possession agreement had been made and the interest worksheets settled so as to produce a start date for interest and capital as the same as the possession date?
Yes, I think it would come back to the question of what exactly Clause 5 provide, what exactly Clause 5 means, because
Yeah.
I can quite see that in crude terms it could be said, well, you got a benefit through your occupation, and you paid interest, and that represented the use value of the money, and so can you draw some crude equivalence between...
It's certainly crude.
Yes.
Well, conversely, one might say the purchaser has got the benefit of hanging on to the balance in the interim. And so it may depend upon how you assess the overall price. But if one's going to be in possession in the meantime, one might think that there would be a value attached to the possession as well.
Well, yes, but I would say to that the answer provided in the contract is that there'll be terms agreed as to possession. So I quite accept, and I've never suggested otherwise, that my client got a benefit in the form of possession. Plainly a benefit over the course of 20 years. Quite what the value of that benefit was to him.
But simply in terms of deferring payment, one can't necessarily attribute the benefit of that to the vendor. Because if the payment comes in stages, the vendor has got the benefit of having the use of some of the money pending completion. But so too the purchaser has got the benefit of retaining the balance in the interim. and then possession is an additional factor on top. So it may depend, may it not, upon, or might it be said to depend upon how the prices are fixed at the outset and what is contemplated at the outset. It's very difficult, perhaps in the abstract, to simply say, well, the benefit here lies with one side or the other in respect of the capital price.
Well, yes, I can see that if the prevailing interest rate for the use of the money was higher than the sums due under the contract, was higher than the interest rate under the contract, it could be said that my client has the benefit of continuing to use the money in the interim, albeit that he also has agreed a purchase price, which he is then paying quite considerable interest on, where it's not like a mortgage or even a loan, because in a mortgage case you get ownership of the property, you get an advance of money, and then that's then used to purchase the property, whereas the vendor here holds onto the property and is able to, as he did, mortgage the property. But even in a loan case, there is money advanced, and so you get the benefit not just that you get to keep some of your money for slightly longer, but you actually receive something. Whereas in this case, my client didn't receive, so parking the question of possession, my client didn't actually receive anything other than the promise of a property in 20 years' time. So I can see that you could say, well, he gets some of the benefit of getting to hold on to his money for longer,
Or at least finding an opportunity to get the money in the interim.
yes, albeit that he'll have to find more as the contract goes on, because the interest will be continues to accrue.
Yeah.
But when one steps back and asks, well, is that the benefit that he really bargained for? My submission would be no, that he's bargaining and he's paying his money. He's not paying interest with a view to thinking, well, this helps me to hold on to my money or for longer, or gives me an opportunity to find more. It's to try and get the property. That's why this entire agreement was entered into. So I would say, if it is a benefit, it's a collateral benefit rather than one that affects the failure of basis. The only case I didn't take you to, or the only case I didn't deal with in any detail that my learned friend cited, was the stock loser case. I say that doesn't really go anywhere, because in stock loser, the question was whether or not an express term for forfeiture of the instalments should be subject to relief from forfeiture. And the majority held that one needed to establish both that it was penal and then that relief would be equitable, and neither were established in that case. However, in this case, we're not dealing with the questions of relief from forfeiture on the equitable jurisdiction. It's instead a question of restitution, either pursuant to the party's contract or a question of unjust enrichment. Finally, by way of reply, on the notion of apportionment, I quite accept, as I've accepted in my written case, that apportionment requires, that apportionment is plainly possible, but I say it has to start with an analysis of what the benefits were that were provided under the contract. If one looks to cases like the Roxburgh and Rothman's case, it's quite straightforward to see how the apportionment worked, because there you had a separate licence fee, which was paid over by the retailers to the wholesalers, and consequently you could see that it was in consideration of them making payment of what turned out to be an unconstitutional levy. But the starting point has to always be the analysis of the party's bargain, which I say takes us back to clause 5 and back to clause 6, on which you already have my submissions. So I think that's as far as I can legitimately go in reply without repeating anything. Unless there's anything more I can assist you with, those are my submissions.
Thank you very much indeed, Mr. Watson. Well, we're most grateful to both counsel for their assistance. We'll now consider the arguments that we've heard and decide on the advice that we will humbly tender to His Majesty.
Thank you very much, ma'am.